attorney helping us. So we've got about 16, I believe, on the committee, and at least 10, according to our rules, have to concur in any opinion. And we have had opinions where 10 don't concur if the answer is yes. We have a substitute motion, the answer is no. We maybe get a majority, so that's it. It turns around, and that's the reason, again, you don't want to rely until you hear from us, because you don't want to, if you're told by the person you called, well, my answer and the vice chair's answer is you can do it, and then 3 weeks or a month later we call back and say, you know, you can't do it. We said, you know, we've reversed ourselves. The committee voted the other way. You don't want to be in that situation. So if you can, hold off until you've received official word. We've also had situations, and last week when we met, it actually happened twice, where we don't have a majority, in which case we have no advice to give to the judge. It's not often, but it can happen. And again, we get these difficult fact situations, and that'll occur. Okay, what else do I want to tell you here? There's a lot. Okay. All right, we do formal opinions. Again, we don't have an attorney helping us, and we have very few, many fewer than the CJEO. Last year, I think we did 2, if I remember right. This year, we have done 1. It will be coming out very soon. And we may do some more, I just don't know. And it can happen, according to our rules, that there can be a minority report on a formal opinion. Okay, if a minority disagrees strongly enough, they can write, I guess, a dissent. I've never seen it happen, but under our rules, it can happen. Interestingly, we do not circulate drafts of our formal opinions to the bench or to the public. We just simply come out with them. That's a difference from the CJEO. We don't even go to the CJE board with our formal opinions. But when we, for example, wrote to Justice Feivel's committee, that was a CJA request. We took that to the board, and Judge Lewis signed the letter. So that's a bit of a difference, if you will. What else? Okay, confidentiality I've talked to you about. Oh, when you get your IR, this again feeds back into confidentiality. When we say to you, okay, we've sent you, we finally said you can write the letter of recommendation. Save the IR when we send it to you. Do not throw it away. Keep it, because we don't link your name to the IRs. We will have the IR in our database, but if you lose your IR and you need it for some other reason, for example, God forbid you have to defend yourself before another particular organization, if you don't have that IR, we don't have it. Okay, and we can't give you the database to go hunting through it. So it's very, and even the judge who you communicated with will not keep your IR beyond the time that that person's term ends. When my term, for example, ends on the ethics committee, or when Barbara's term ends, we must destroy all our data. We have to have a bonfire. So it's very important that you got an IR, and it's you want to keep that somewhere in your file, nice and safe. But in any case, a couple of things regarding what we don't do. We do not opine on questions of law. We do get questions, for example, I've been asked to serve on the City Harbors Commission, can I do it? Well, technically that's calling for a question of law. There is an ethical ramification to it, but if you're asking us for a legal opinion, we will not give it to you. That's number one. Number two, we don't ask for, we won't give you a hypothetical. It really has to be a situation involving you. Number three, we will not opine for third parties. Now there's a distinction. If you call up and say, the judge down the hall is giving rock concerts in his chambers, and I don't know whether or not that's ethical, we're not going to answer that question. On the other hand, if you get a call, if we get a call saying, the judge down the hall did X, Y, and Z, and under Canon 3D, do I have a reporting obligation? We will answer that one, okay? Now, let me tell you, by the way, we rarely, with respect to reporting obligations, I'm mildly surprised after all these years that we usually, almost never, I would say almost never, immediately advise a report to the CJP. We usually say counsel the person, talk to the person. If that doesn't work, go up to the person supervising or PJ. But we don't immediately go to DEFCON 5 and say, call the CJP. But I will tell you, it has happened once. I do know of one situation, I'm not going to tell you when, but we did advise an immediate report to the CJP, and we all kind of looked at each other and said, has anybody ever seen this before? And the answer was no, we hadn't. So that can occur. At any rate, I think that's pretty much it. If any questions, I'll be happy to answer them later on.
Okay, so I'm Erica Yu, and I'm the chair of the Commission on Judicial Performance. I think this is such a great program because it is allowing us to highlight the distinctions that we have in the common areas that we work on. The Commission was started in 1960. It is a constitutional body which was enacted by the people of the state of California. It is the first judicial discipline body in the country, and our discipline body is based basically on the state bar. So then many states adopted the CJP's rules, and now there's a commission in every state in the union. We don't give advice. We don't write opinions. Our charge is the protection of the public, which I didn't know until I actually went on the commission. I've been on the commission now for approximately 5 years. I always thought the commission's job was to punish, but actually it's to protect the public and to ensure the integrity and the independence of the judiciary. Since the inception of the commission, it has actually been changed by constitutional amendment 5 times. So those changes that have occurred, the primary largest one was to change the configuration of the commission. It used to be that the commission was comprised largely of judges and a couple of attorneys. And Joe Cachet was one of the attorneys on the commission at the time, and he has told me, you know, Erica, basically the lawyers didn't really say anything and the judges just ran the show. So in 1995, the people of the state of California instituted an amendment that changed the membership of the commission. Now there are 11 members, 3 of whom are judges. So the 3 judges are appointed by the Supreme Court, and of those judges, 1 is an appellate court justice and then 2 trial court judges. There are 2 attorneys appointed by the governor, and then 6 public members, 2 appointed by the governor, 2 by the Senate Rules Committee, and then 2 by the Speaker of the Assembly. And I don't know if it's, in terms of the commission's research and statistics, the addition of public members hasn't really changed the discipline. I think people were really concerned that all of a sudden judges would be disciplined more strictly or more frequently, but we haven't seen that occur. We're fully aware that public members often have no grounding in the law or judicial ethics, so we have an internal training system for all members actually, but mostly from public members who join the commission. We just received the appointment of a brand new public member. Her name is Patil Kasparian. She's appointed by the Senate Rules, and she will have her first meeting in May. Some of the other changes that occurred was that the commission initially started as a fully just investigative body. It had no power to issue any sanctions or discipline. It could only make recommendations to the Supreme Court. Now, through amendment, the commission has full authority to impose discipline, and also it was given authority over retired judges for conduct that occurred when the judge was in office, and it shares now jurisdiction over subordinate judicial officers with the presiding judge. There's some additional changes, but those are sort of the highlights of the bigger changes. In terms of our charge, what we do is we receive complaints, and complaints they have to be in writing, but they can be anonymous, etc. There's some thought that the commission is trolling appellate court cases and trying to find, judicial misconduct in appellate court cases. But just so, I actually wanted to look that up and see if that was true. And so I looked at the 20-year study that the commission released about 2 years ago, and it's on the commission's website, that looked at all the discipline issued by the commission in the last 20 years. In that 20-year period of time, only 5 cases were investigated of judicial misconduct allegedly found or mentioned in appellate court cases, and actually only 8 cases in 20 years resulted in any discipline based on what was read in an appellate court case. In terms of our investigation, the commission usually receives about 1,100 to 1,200 complaints a year, and every single complaint is reviewed by the commission. So the commission must review every complaint and then decide as a commission, and staff doesn't decide, the commission decides whether an investigation should be opened. The standard for us is whether or not there's a prima facie case. If there's a prima facie case, it triggers our duty as commissioners to protect the public and institute an investigation. Once an investigation is commenced, if there's enough there, the commission won't contact the judge, because we're fully aware that 90% of the complaints are resolved without any discipline imposed. So we'll talk to the complainant. If the commission votes to open an investigation, sometimes they send transcripts or other things. 25% of the cases that are opened are actually closed without ever contacting the judge, because there really wasn't enough there. And then once we need to go further, the judge is contacted, the judge receives a letter now at work. It used to be the judge received a letter at home, but the judges prefer to receive it at work in an envelope marked confidential, and there's no Commission on Judicial Performance on the envelope, although the address, 455 Golden Gate is on the envelope. It's my job as chair, I sort of saw it as to make sure that the commission's procedures are as transparent as possible. I know that there's frustration and fear because everything is confidential. So much is confidential until the commission's cases go to formal proceedings. And so that kind of breeds mistrust. So my goal is to make the commission as transparent, or its policies and procedures as transparent as possible. I found it interesting that a judge told me after 2 cases against that were investigated about that judge were closed without discipline. That judge, who had counsel, told me that that judge didn't even know how many members were on the commission and what the commission makeup was. And that kind of concerned me, because I thought, well, that judge even had counsel. And I asked staff, can we please put something in the investigation letters? Because I can imagine getting a letter, being stunned and concerned, and somewhat embarrassed and not knowing who to talk to ask questions of. So Victoria Henley talked to Mark Jacobson. He thought it was a great idea. Victoria, Mark Jacobson, myself, and the judges on the commission put together something that's page 10 in your handout, which now is included in every investigation letter that goes to every judge, because we wanted to make sure that people just had a starting point to understand, well, what's the process? And Mark Jacobson's name and number is there at the end so that people can follow up with him, and he's very welcoming of questions and happy to answer those questions. In addition, I use the website a lot, and there's a lot of valuable information on the website, but it wasn't really user-friendly. And so I tripped up on things, told staff about it, and we've redone our website to make it much more user-friendly. We've also put together compendiums, which is a compendium of all the discipline that the Commission has issued in the last 20 years or so on certain topics. So there is a compendium now on all self-represented litigants cases. There's a compendium on all discipline related to interaction with interpreters, or all discipline related to interaction with court staff. And those will be put up on the website shortly. I think that I've used them as a teaching tool in the past, and they're actually very valuable. So if you're from LA Superior Court and you're in the hub, now you can go on the website and look up the compendium printed out and kind of gauge for yourself what conduct has gotten us in trouble in the past, what conduct should I avoid. If you're a presiding judge and you've gotten a complaint from an interpreter that the judge is doing X, Y, or Z, you can get the compendium and say, okay, is this falling within the cases that the Commission has issued discipline on, or is this something that I think that's outside that scope? So those are some of the things that we've done. Just so you know, since I've become chair, judges have also called me. I get random calls. Sometimes people are venting, which is perfectly okay, and sometimes they really, have some I think great suggestions, and I've taken those suggestions to the Commission and to staff, and we keep them in mind when we move forward. So we have heard, for example, that some of our case studies mentioned in the annual report are too truncated, and it's not helpful. So while we definitely want to maintain confidentiality of the judges where they've received private discipline, we're trying to give more information where we can on our case study so that it can be more useful to the judges. So like everyone here, I'm happy to answer any questions that you may have. And I'm also happy to hear about, if you want to just talk privately, not about cases, but about any suggestions or questions you may have about the process. Two things were raised that I just want to mention. One is recusals. So the commission members do recuse. You can imagine that judges on the commission know other judges and are friendly with them, so we recuse. Once we recuse, the judge who's the subject of the investigation is sent a letter informing them that the judge or the members recused, and we take our recusal seriously. So the recused member gets no information, no reports, nothing about the case. Staff also recuses. So we have a staff of approximately 12 attorneys. We're supposed to have more, but like everybody else, we've got attrition, we've got budget issues. The commission's budget, by the way, is separate from the branches and is separate from the Judicial Council. The commission has its own line item budget. So staff, the research attorneys or investigating attorneys can also recuse. And then we've talked about confidentiality. The commission very much believes that its charge is to maintain confidentiality, and there's a U.S. Supreme Court landmark case that talks about why confidentiality is so important, because judges will be the subject of unfounded complaints, and those complaints should not be aired in public. And there have been hearings in front of the commission where the judges said, I know it would not be X who complained about me because X loves me, and we would know who the complainant is, and the judge just doesn't know and may not be right in trying to guess who that complainant is. Once the matter goes to a formal proceeding, however, then all confidentiality is lifted. There's discovery. It's not like civil discovery, so it's not as broad, but there is definitely discovery. And the complainant's identity is revealed. The complaint itself, however, is still confidential unless there are rules that allow for that to be turned over. So I think that's it for the commission. Thank you so much for your attention.
How do you use the IR? So if an IR has been completed, it's written, the person has it in its binder, and unfortunately it rises to the commission level. What do you do with that? And then the second part of that is, and I don't know if it has occurred yet, with regards to the CJEO opinions, if there's been a formal opinion issued, and now that issue is before the commission, and that particular judge has relied on that opinion.
Those are great questions. So the commission meets 7 times a year, and before each meeting we get a beacon box filled with paper. My court clerk has to lug it upstairs, and it's all the reports that we receive from our research attorneys. And the reports are really well done, and they talk about the underlying area of law, the fact